Our next case is in re AD. Each party will have 15 minutes to present their argument. Counsel, how long would like to reserve for rebuttal?
4 minutes. Yeah.
Thank you. The court will note the 4 minutes, and I will, as you know, be keeping the time. Your time, if you're looking to your left, that circle will be the top one as you're going down. When that gets to 4 minutes left, your rebuttal will have started. I'll try to let you know about 5 minutes of that time. You have 1 minute left of your time.
Okay,
And again, counsel will try to let you know about 1 minute left of your time when we get to that point as well. Thank you, Judge. The arguments are being recorded, so when you approach the podium, please make sure you state your name so we introduce yourself for the record, and stay behind the podium and speak loudly so we can both video and audio record you when you're speaking. You should not use the name of any child, minor, or victim, as we're using AD here as the indication for the defendant in this case. Please do not use any of those full names. You can refer to initials such as the child or initials when you speak. We read your brief and are ready to proceed whenever you are.
Thank you, Judge Stevenson. Your Honors, may it please the Court. Andrew Harris on behalf of the appellant, juvenile AD. I'm going to limit my remarks today largely to our first three assignments of error and address them largely together. But I want to start by talking about what I think the crux of this case is, where you can get most of the information you need to make a decision, which is the State's Exhibit 2, which is the hallway surveillance video of the struggle between the officers and my client. 4 seconds into that video, AD attempts to walk past one of the sheriff's deputies who has been questioning her. Immediately, she is descended upon from both sides. That is 6 seconds into the video, 2 seconds after she has taken this step. The Springfield police officer, who, as you can see in the video, is a full head and a half taller than her, approaches her from behind, pins her arms behind her back, and by 10 seconds she's been knocked down for a first time onto the bench, into the bench area where she had been previously sitting. By 29 seconds, a third law enforcement officer, the other deputy, has entered the affray. The officers pin her against the wall while continuing to hinder her from using her arms. The four of them eventually separate from the wall, and then 1 minute into the video, the sheriff's deputy who had been questioning her sweeps her leg. The 3 officers land on top of her as she falls to the ground. She hits her face on the bench on the way down. Again, this all occurs over the course of less than a minute, so just looking at the clock, it's taking me longer to describe what happened than the amount of time it took. So rather than kind of walk through my assignments of error in order, I'm going to address them largely together by looking at the charges, the adjudications. Starting with the assault charge, we've raised 2 challenges there. The first is a search and seizure challenge to the excessiveness of the force employed by the officers. As we've cited in our brief, this is a reasonableness test. It's based on the objective circumstances of the event. So the factors you look at are the severity of the crime, whether the suspect posed an immediate threat to the safety of the officers or anyone else around them, whether they're attempting to evade arrest, whether they're actively resisting, things like whether the incident occurred at night, whether the suspect is intoxicated. So these are the factors you have to consider, and I would submit that applying them here to the facts in this case indicate that this was objectively unreasonable force. Restricting the use of her arms, taking her down to the ground, bloodying her nose. I mean, the state has, in its brief and during closing argument, made much of the fact that there were, in their telling, use of force tactics that the officers did not use. That's, first of all, not the test. It's maybe one consideration among others. The crime at issue here was a speculative belief that she might be in indirect criminal contempt of some judge or magistrate's order to stay. The officers, objectively speaking.
So, I mean, I look at this, and I appreciate you folks that looked at this under the realm of this was an arrest from all this part of the country of a resisting charge. But really, the initial activities with her seem to be more of a caretaker, court security kind of function. There's no thought they're gonna arrest her at the start. They approached her to make sure she wasn't gonna leave court. They say to make sure she wouldn't run outside and be safe. So how do these tests apply, other than looking at where their acting's reasonable? All these factors are talked about as portion of arrest, as, you know, if they were arresting her, if she was committing a crime. She clearly really wasn't initially committing any crime.
Sure. And so, a couple of points. First, just to be clear on the record, there are two interactions. The first, he approaches her, asks her a few questions, doesn't get, information about where she's come from, where, she's supposed to be. He goes back to the front desk. He makes a few other investigative efforts that don't, in his telling, yield any other basis for, arresting her at that point. His testimony is that when he approaches her a second time, which is what the video depicts, he has no more information on which he would base an arrest at that point. Whether an arrest occurs, like whether excessive force occurs, these are objective tests based on a totality of what is happening. I would submit that it probably does not constitute arrest. The deputy has kind of stepped with her as she steps to the side of him. But when the Springfield police officer pins her arms behind her back, and all of the officers proceed to restrict use of her arms, at that point the deputy's testimony is that he did have his handcuffs in his hand. The video corroborates that. I've watched it back and forth 1,000 times. I'm not sure which hand exactly his handcuffs are in, but he does either take them out of his vest or from his belt.
Do the officers in the testimony below ever say they were arresting her, or do they continue to say they were detaining her because they were told by the court to detain her?
So their testimony was that no arrest occurred until she kicked one of the deputies. Now,
so at some point they do change from our activity with her, change from detaining to arresting at some point in time in this.
According to the officer.
According to their testimony.
Correct.
Their testimony is, we changed, first we're detaining, now we're arresting. Okay.
Now, and if you look at the record, their conduct doesn't really change based on what the deputy testified to, his shift in subjective intention. They are, before, in his telling, arresting her, pinning her arms behind her back and trying to handcuff her. After, he expresses, that it was now his intent to arrest her. They're pinning her arms behind her back and trying to handcuff her.
Did they state to her that we're placing her under arrest at any point in time? Did they testify?
So there's no audio on the video. It's not clear. She was informed certainly after she fell, I believe, that she was under arrest. They didn't express that contemporaneously as she was falling, certainly, or while she were.
They eventually testified, we told her, hey, we're placing you under arrest.
Yes.
Okay.
But to your point, prior to that kick, at least the testimony was, we were detaining her, in the officer's words, in the deputy's words rather, for the purposes of doing an investigation to see what was going on. Maybe that's a good place to pivot into the defense we've raised to the unlawful arrest charge, which is, was there a lawful arrest? I submit for all of the reasons we talked about before, that there was an arrest at the time. They pin her arms behind her back and start struggling to cuff her, but that it wasn't lawful as required by the statute. The state, in its brief, raised that a telephone tip typically is enough to raise probable cause to arrest someone. I submit that the case they cite for that proposition doesn't go nearly that far. It involved an identified defendant who was relaying criminal conduct that was occurring in real time while he spoke to the dispatch. The facts here are that the deputy who received the call wasn't really sure who had made it. He understood that there were court offices other than judges and magistrates, certainly in the courthouse. The officer who went to speak to the juvenile had in fact not spoken to the person on the phone. It was the other deputy who went and talked to my client. So likewise didn't know who called, likewise didn't know the nature of the request for her to turn upstairs. Ms. Gatz, the administrative assistant at the Family Resource Center, testified that one of our kiddos went down, can you send them back up? Also said that I didn't order her to come back up because we, the FRC, lack authority to tell people that. And her supervisor, Ms. Karras, testified that she told AD she was free to leave. The objective circumstances here, I submit, are just that there was not any reasonable suspicion that AD was engaged in criminal activity that would have justified a temporary investigative detention or a stop for officer.
You're running low on your time. Let me just ask you this about your third assignment of air. It seemed at some point during the discussion of whether or not we should let this person testify as an expert, the trial court said, okay, I'll give you continuance, you can get your own expert at that point in time. And I don't recall from the record, at any point did counsel say, never mind, we don't want to get an expert, or do they deal with that fact they're not free to have an expert in this case of your own?
So the record is that he was given a continuance. So to the extent that there's a prejudice from the discovery violation, the amount of time between the first and second hearing may have done some curative work there. What is, I think, substantively still wrong about
and I appreciate that. I don't know. I couldn't see in the record where they ever went back on the record and counsel said, never mind, we don't want an expert, or we do want an expert, but we need more time. I don't see that ever being addressed anywhere.
I don't think that was ever put on the record. That's correct. And otherwise, unless there are questions about the evidentiary assignment there, I would rest on basis of my brief.
And you'll have your form.
All right. Thank you.
I'm going to keep my glasses on for this one. May it please the court, again, my name is Rick Raley. I'm appearing on behalf of Summit County Prosecutor Elliot Kolkovich in the Appellate State of Ohio. I do want to start with agreement. I agree with Mr. Karras. I think State's Exhibit 2 is important, and that this court should review that very closely. And I think it also needs to be considered within the context of Deputy Fickus' testimony. He is one of the deputies involved in this. When you watch that video, you see AD deliberately kicking at the deputies. It's not a flailing kind of motion. It's not something that's incidental to them arresting her. It's something she is purposely doing that you can see based on what her conduct is. From that, I think there's clear evidence of an assault on a police officer. And I think that adjudication has to stand quite firmly. It's quite easy to let that one stand. We cite
you have to consider this issue of excessive force as an affirmative defense to that. Is that fair? We have to at some point consider that. I know it's in assignment of number 1, you say plain air, you didn't raise it, but it seems to me that is a defense to resisting arrest if the officers were using excessive force.
The excessive force, I believe, and the lawful arrest would both go towards the resisting arrest. So I think that is something that should be considered in the plan of the whole case, but it is under those assignments there that I think is appropriate. And since excessive force is affirmative defense, it should be only under manifest weight. And I would.
Case law that says excessive force does not apply to assault of a police officer. Certainly there's a state for Jones, and I would agree that applies to resisting arrest.
Correct, yes. I'm not sure if I cited it to you. I can just tell you in my practice that's what I thought, so I hope that's accurate. I'll put it that way. There is testimony from the deputies that they affirmatively decided against using more, I'm not going to say extreme, more aggressive use of force tactics against her. They decided against using this and that and this. There's testimony about that. Because they understand who they're dealing with. They're dealing with a juvenile female. They understand that she is not, they didn't receive a phone call that says, hey, she just committed a murder. They said, someone's coming down, she's unaccompanied, she can't leave, it's unsafe. And that's what they concluded.
Did they say that?
Sorry.
She can't leave, it's unsafe?
They said, stop her, send her back upstairs. And then they were worried because of her age and where they were and their job as courthouse security and we're a juvenile court, is they concluded, based on their experience and training, that it would be unsafe for her to just walk out of the building unaccompanied.
So the person that made the phone call to the deputy said, stop her and send her upstairs.
That's my understanding, yes.
That's the deputy's understanding of what he heard.
Yes, correct.
And it's also the testimony of the person who made the phone call?
I can't recall the testimony of the person from the phone call. And quite frankly, I would tell you that it is an objective, and I think a police officer is entitled to rely on what's relayed to him in a ongoing, fast courtroom security, caretaking kind of a function. That was what was relayed to him, and that's what he acted based on. So I really think that it's kind of a red herring what actually was said, because it's more about what was communicated to him and how he responded to it. And I also think it's very important within the circumstances to think about how AD responded. Because it wasn't as though deputy walked up to her, guns ablazing, and hey, you're under arrest right now, you gotta stop. He wanted to engage her in conversation. And she elevates the confrontation into verbal abuse. You can't stop me. It doesn't give her name, not following commands. All kinds of things that elevate this to the point of, hey, I need to calm you down so I can know what's going on. And we're at a courthouse here, you can't behave this way in a courthouse. And then we get into a physical confrontation where she starts kicking at him, she swings at him. And the horror, there are some pictures in the record of what her injuries were, which look horrific. There's blood that you will see. That injury occurs because her behavior and way she is resisting and flailing about after she's doing these deliberate kicks, that causes her to fall and injure herself.
Not sweeping the legs?
I did not see the officers sweep legs or anything like that. I did not see them try to take her down. It was her actions, and she fell.
It would seem to me that it would be agreed when the interaction with the defendant starts, there's no intent to arrest her at that point in time. This is some form of safety, court control, responsibility that the officers or deputies are taking to be involved with her, not to arrest her because she's been committed a crime.
Absolutely.
In the initial starts of the conversation, it sounds to me like the record is saying they're trying to gain information. They're not trying to arrest her, they're trying to find what's going on.
Correct.
Did the officers ever at any point say to her, you're going to be under arrest if you don't do this, or we'll place you under arrest?
I don't think that there is evidence on that, so I don't want to speculate whether that was said or not. It is unfortunate that this surveillance video does not have audio, and they do not have body camera footage in the courthouse.
But the officers, to your recollection, don't say, yes, we told her at this point we're going to put you under arrest.
To my recollection, yes. I will say that her conduct in refusing commands, in being verbally abusive, and causing a scene in the courthouse would create disorderly conduct grounds. It would, and then also in the case of trying to get her under control and detaining her, her deliberate strikes.
The officers testified that it became our intent during this interaction to arrest her because she kicked an officer, that felony assault an officer, or she was obstructing business.
There is testimony that that eventually was their intent. I don't think that there's a clear subjective, we know exactly at this minute what it was. I can tell you objectively, a police officer looking at it and seeing that, you could say, based on that conduct, you are subject to arrest for disorderly conduct. And she was charged with that, ultimately found not guilty. However, I'm sorry, not adjudicated. I would say that that is immaterial, though, as I cited in the court, it's about probable cause, not an actual final finding on the disorderly conduct. So I wish that there would be a clear, precise timeline about when that subjective intent developed, but I do not believe we have that, except for after the fact, after she assaulted the officers. So, you know, to the extent that we go into this discovery issue, I don't believe that there wasn't a responsive expert ever was retained. There is no evidence in the record about the use of force issue that is addressed in the fourth assignment of error.
When the report was given to defendant below, I mean, the trial court generally placed a lot of weight on, hey, you got this report a while ago, you should know this person's going to testify after this date. Was the person designated any witness statement that they were an expert, and that was the purpose for calling the sergeant or the officer who testified?
There was the trial judge engaged defense counsel on that point. The sergeant was identified as a witness, not specifically as an expert. However, the trial judge concluded, well, you were given a report here, and the only involvement the sergeant had was about this use of force investigation. what else did you think he was going to testify about? Regardless, there was a multiple months of continuance in the middle of the hearing to address any prejudice that may have arisen from the late disclosure allegedly about him being an expert witness.
Do you concede he was an expert, or there's some other purpose for calling him an officer?
I can't think of any other reason why Sergeant Harbor would have been testifying unless it was about use of force. So I think that it's appropriate to think he was an expert.
During his testimony, was he asked to give an expert opinion?
He gave an expert opinion about whether it was reasonable force or not, yes. I will say though that, I talk about the invited error, and the reports are actually introduced at defense request. We also have that based on the engagement with the trial counsel during the testimony, there's no discussion of the ultimate issue fact, no objections raised on that. And at the end, it is a bench trial to a judge who's able to determine what he believes from the evidence that he's received. So with that, if there are any further questions, I would just ask you to confirm the adjudications.
They rely upon State versus Curley Jones.
Yes.
And do you think it's not our jurisdiction, so it's persuasive authority.
Right, yeah.
Do you think it's something that this court should follow?
So I actually, there's Curley Jones was his, mine's Jones, so keep it clear. And it's 8th District case law, it's kind of choose your own adventure, as we know. I would say that the Jones case is more on point on the facts we have here. For Curley Jones, I think we see the description there, and it's unfortunate we don't know the whole record in Curley Jones. But there, it's part and parcel of resisting and the assault, because it's kind of and I've seen this before in my practice, when you're pulling someone out of the window and you're flailing about and you make incidental contact with a deputy or an officer, I can see why you would say that's part and parcel.
Well, the notion seems to me in Curley Jones, as I read it, that as to intent, the intent of the defendant in Curley Jones, while kicking and all doing all this, is part of the resisting arrest. So that intent was all that one act, so that can also be intent for assault on the officer. And that seems to be the premise they went. Does that strike you as odd in any way?
I don't read Curley Jones that same way. I cite the Davis case from the 5th District, which I think is a good roadmap for how Curley Jones can be distinguishable in certain cases, and I think it applies here, the Davis reasoning for those paragraphs. I think with this Curley Jones case, it's really about, there's no evidence that there's a deliberate, forcible punch or a kick at the officer. I think when you look at State's Exhibit 2, you're going to see a deliberate force use against the deputy Fickus. So that's where I think they're distinguishable.
The officers here testify they suffered harm?
They did, yes. Deputy Fickus testified that it caused him harm, especially on his legs. And I do think that that action of hers, they're described by mule kicks as my opposing counsel, they are very separate from anything else that's done to try to get out of having your hands tied behind your back for an arrest. So that's where I would go with that. Anything else? Thank you, judges. Thank you.
Thank you. You have your full rebuttal time, counsel.
Thank you, Your Honor. As it relates to, whether the deputy swept the leg, I would, first of all, that was Deputy Fickus' testimony, that he performed a leg sweep. And it is corroborated in the video. About 1 minute into the State's Exhibit 2, you can see him use one of his legs to undercut one of AD's legs. So that's consistent with his testimony. I think the idea that he didn't sweep her legs is just not supported by the record.
So is that the excessive force? I mean, your brief left me a little clear exactly what you were saying was the excessive force. The second officer coming in, when do we hit the point that now this is excessive force?
Sure. So controlling her arms might have been, I think, excessive. Not that I've isolated a timestamp in our brief, but if I was pushed on doing it today, I would say.
In your view, is any attempt to restrict her in this instance excessive?
The initial interview, sorry.
Yeah, any attempt to restrict her in any way, was it excessive at the very start?
No, and I would
Just when
submit
they
that
started to
what you
put her
can-
hands on that or her and try to control her.
correct, and I would say, what you can see him, what you can see Deputy Fickus do, kind of before hands are placed on her, is sort of step in her way to prevent her from going around him. That's not excessive on these facts, I think. But subsequent to that, starting at, probably 6 seconds at this, if I had to isolate where on Exhibit 2, I would submit the excessive force started. That's where I would put it. And, whether excessive force occurs, again, it's a totality, it's a objective test based on, all of the objectively observable factors. There are 3 officers, they're all bigger than her. In particular, the Springfield police officer is a lot bigger than her. He initially approaches her from behind. I think it's clear that she's scared, based on certainly the video, but the balance of the record as well. To that point, I think the facts really are aligned with the Curley Jones case, and I think you actually stated in your question to opposing counsel, stated the rationale correctly, that, knowingness, traditionally understood, is, performing an action, with the substantial certainty that a result will occur. And in that sense, probably consciously, she made the kind of synaptic connections in her brain, that said kick. And that's what happened, I submit, in Curley Jones, and that's what happened here. It was part and parcel of the struggle that was already underway. On the evidentiary point, to the extent, it was invited error, I would, just rest on our brief. I think it's an important concession that the state's made, that this is in fact an expert report. I would encourage the court to look at the cases we've cited for the proposition that, expert opinion on the reasonableness of force, in the form of presenting interdepartmental memos, these reasonable use of force reports is just not appropriate fodder under 702. And with that, unless there are further questions, I would rest on my brief.
Thank you.
Thank you.
The court will take the matter under advisement and issue a decision in due course. The clerk of court will mail a copy of that decision to you when it's released. It'll also be available on the High Supreme Court website. With that, I'd like to thank both of you for your presentation on today on behalf of the board.
Thank you, judges.